The Nigerian Senate has moved to cut off statutory allocation to local government areas whose chief executives and councilors are not elected. The Senate set this in motion on Friday when it urged the federal government to cut off appointed local governments from the allocations. The resolution followed a motion by the Senate Minority Leader, Abba Moro of the People's Democratic Party from Benue South. While setting deliberations in motion, the senators extended the motion to include sanctions to other states in the country that had put in place unelected council executives. While they condemned the arbitrary dissolution of democratically elected officials of local governments in Benue and other states in Nigeria, the lawmakers urged the governor of Benue State, Hyacinth Alaya, to adhere to his oath of office by obeying the rule of law and defending the Constitution. For a conversation, we now turn to Senior Advocate of Nigeria, Kunle Adegoke. Good afternoon and welcome to Arise News. Thanks for joining us for this discussion.
Thank you. Good afternoon. It's my pleasure to be with you this afternoon.
Well, it's clear that there's a very urgent need for local government reforms. In the intro we just read, there is a proposal to sanction those who act otherwise and remove elected officials from the local governments. What's your take on whether or not this will be enough to stop some of this bad behavior?
Thank you very much. I believe the step being taken by the Senate is one that is in the right direction. All efforts in the past to get governors to obey the Constitution and observe the letters of the law have proved abortive. It has become imperative that all stakeholders must prevail on the governors to let the local governments work, to let them function. It has become an aberration that governors that were democratically elected have constituted themselves to unnecessary impediments to the democratic evolution and existence of the local governments. I believe that this step being taken by the Senate to cut off the source of financial supplies, which many states have been using to fund their own projects, denying the local governments their statutory allocations, will put some of these governors in check as to allow democratically elected local government councils to be in place in their various states. It is unconstitutional and it's illegal for any governor to arbitrarily dissolve a local government council and appoint caretaker committees, even when such is contained in the law of a state establishing the local government council. Such a particular law is unconstitutional. I believe the step being taken by the Senate will achieve a lot in this circumstance.
But the Benue State governor believes senators had been misled, as he says it was the State House of Assembly as empowered by the Constitution that dissolved the council members and that a caretaker committee was put in place to avoid lacunas. So he says the allocation should not be withheld. I would like to know your take on his line of reasoning.
The argument by the governor, His Excellency, is quite wrong and palpably incorrect. The attempt to guillotine the Constitution by presenting a facade that such an illegality originated from the State House of Assembly itself is an unconstitutional step being taken by whatever organ of the state, whether the House of Assembly or the governor or any other organ of government of the state. In this circumstance, the Constitution has stipulated the existence of local government councils to be one that must at all times be democratically elected, which is the one that the Constitution says is hereby guaranteed. Now, it is the duty of the House of Assembly and the executive of the state to ensure that the local government councils at all times shall be democratically elected. For the House of Assembly of Benue State to have put in place a stratagem by which it wants to defeat the letters of the Constitution is undemocratic, is disappointing, and completely egregious on the part of the members, the honorable members of the House of Assembly. And for the governor, who was democratically elected, to have kowtowed to that kind of reasoning shows the level of competence of the governor and his ability to reason democratically and constitutionally. In the circumstance where Section 7 of the Constitution has prescribed that local government councils in the state shall at all times be democratically elected, it is impossible, it is not allowed, it is not permissible for the House of Assembly to now put in place a structure that would defeat the democratic existence of the local government, either by amendment or by enacting a law that would allow the state governor to put in place caretaker committees or any other structure contrary to the provisions of the Constitution. Now, where the Constitution has stipulated that the local government councils must at all times be democratically elected, the implication is that where we have a structure being put in place by a state government, whether through the House of Assembly or through the governor of the state, whereby caretakers are being appointed into local government council offices, the implication is that local government councils are not in existence in that particular state in line with the Constitution. And the Supreme Court has on so many occasions, the Court of Appeal has on so many occasions pronounced on such practices by the governors and houses of assembly of various states, to the extent that the Supreme Court, for instance, in APC and Enugu State Independent Electoral Commission and Ekiti State Government and Olubomo, the Supreme Court was quite categorical to say that putting in place a caretaker committee, contrary to the stipulation of Section 7(1) of the Constitution, is an illegality, is an unconstitutionality. It is null and void. In law, when we say a particular act or step or provision of the law is null and void, is unconstitutional, the implication is that that particular thing does not exist. The implication in those states, particularly Benue now, the implication is that there are no local government councils in Benue State as we speak. So far, the structure being put in place by the state governor and the House of Assembly in that state, insofar as those structures are not consistent with the provisions of the Constitution, then they are a nullity to the extent of their inconsistency with the Constitution. The implication is that the federal government will be acting unconstitutionally to be releasing local government council funds to states where there are no local government councils in existence. So it is forbidden for the federal government in this instance to release such allocations meant for such states to the governor of that particular state. We all are aware that all the while the governors have been appointing caretaker committees and dissolving democratically elected local government councils is to make sure that people that will be there will be their stooges, will be their errand boys, that will not be able to query what the governor is doing with the local government council funds. And that is why local government councils are no longer functioning in Nigeria. There are many roads, there are many responsibilities, constitutional responsibilities laid down by the Constitution for local governments that practically almost all the local governments in the federation are unable to perform, except in such states where they are allowed to actually function. For instance, in Lagos State, we can see what some local government councils are doing, like the one recently in Bariga that opened a state-of-the-art, I think, health facility or something of that sort. Then that means that in such a place, where we have a democratically elected local government council, that is the only place that is entitled under the Constitution to receive local government council allocation in line with Section 162 of the Constitution. Where such councils are not democratically elected, then it will be unconstitutional. It will be an aberration for the Attorney General of the Federation, for the Revenue Mobilization and the Revenue Allocation Commission to continue funneling money to such states, to such non-existent local government councils in such states where the governors are perpetrating these aberrations.
And Senator Adams Oshomole actually recently spoke to a bunch of senators, and he said that the Supreme Court had pronounced that the state governors had no power to dissolve elected local government officials, and he himself had to resist the pressure to dissolve elected officials of the local government as a governor. With these proposals in place, why is it so tempting for those in the local government to rearrange and implement their stooges, so you say? Why is it so tempting for them to upend the democratic rule when they get into government like that?
Yes, you know, the funny thing about our system is that an average person who is a beneficiary of a democratic process, when he gets into power, will now be violating the same democratic process by which he came into power. And just as a philosopher once said that power corrupts and absolute power corrupts absolutely. Our governors have seen themselves as demigods, as potentates, they function like monarchs who consider themselves to have absolute powers. And to that extent, they are not ready to reason in line with the law. They are not ready to reason in line with the Constitution. In actual fact, in any state where the governor unilaterally dissolves the local government, if we have a House of Assembly or House of Assembly members that are really worth their salt, who are actually conscious and are educated enough to realize what responsibilities and mandates the Constitution has trusted onto them, in such a state, you expect the House of Assembly to commence impeachment proceedings against such a governor. It is an impeachable offense for any governor to violate the Constitution, to treat the Constitution as a mere piece of paper that is not worthy of the respect that the Constitution has stipulated should be accorded its own self. That is the ground norm. That is the source and origin, the ultimate origin of all other laws. It is the Constitution that confers legitimacy on every other law, whether enacted by the House of Assembly or the National Assembly or even judicial pronouncements. All other laws derive constitutionality, originality from the Constitution. Without the Constitution giving legitimacy to any piece of law, that law is inconsistent with the Constitution and will be a nullity. To this extent, when you now have a governor who considers himself to be a potentate and not a governor with powers limited by the Constitution, he will want to override and ride roughshod over any other institution of government, over any other law that may want to prevent him from being able to carry out his illegality. For instance, the various state governments in Nigeria, except for probably a few, like Lagos and probably Kano and Rivers State, I think those are the ones that are generating sufficient internal revenue that can do something meaningful for the people of their various states, most essentially Lagos State. If you look at most other states, they find it impossible, they find it difficult to be able to generate sufficient internal revenue as to be able to take care of the state responsibilities. This is not merely just a problem with the Constitution. It is the inability of majority of these governors to put on their thinking caps and reason critically on how to assist the state to generate sufficient revenue internally to develop the economy of the states. There is what we call developmental economics, that anybody who aspires to be a governor, president, or local government chairman ought to be educated in inability to be able to reason critically and engage the economy of the state in a way that will bring developmental strides by which the state can have sufficient revenue to run its budget, to run its activities, and not merely be depending on federal allocation is the major problem that majority of these governors are having. And when you look at this crisis that we are confronted with, majority of them now rely on the allocations coming from the federal government, from the center, that allocations meant for the local government councils. They divert the allocation meant for the local government councils. They steal the allocations meant for the local government. Some of them would collect, let us say, 100 million naira for a local government and will give only 10 million naira. They will remit the 100 million to the local government, only for the local government to funnel back, to remit back 90 million naira to the state government, creating a facade of having complied with the constitution, because such monies coming from the federation account, landing in the joint state allocation account, meant for the local governments ought to be funneled directly to the local government councils. In fact, the states are supposed to even appropriate a portion of their own internally generated revenue that should go to the local government councils. But rather than observing these provisions of the law as laid down in section 162 of the Constitution, what majority of these governors have been doing is now to divert the money coming directly from the federation account and meant for the local governments now to a special account by which they are now carrying out their own activity. They will steal a substantial part of the money. At times, they will use the money to do some projects they will claim to be projects done by the state governments from state-owned finances, without disclosing that the money was actually meant for the local governments, that they diverted these monies to some other things. Now, these are impeachable offenses. The majority of this, so because of the inability of the state governors to generate sufficient internal revenue by which they could run the affairs of the state, they are not only depending on the federation, on the government at the center alone for their own finances, they are also stealing, they are diverting allocations meant for the local governments in order to run their own affairs. It is very sad. It is very disheartening. And that is why it is imperative to check this anomaly. The statement credited to the former governor of Edo State, Senator Adams Oshiomhole, is correct. Is a very sound position. Every local government, every state house of assembly should resist these illegalities being perpetrated by the governors. And wherever they don't allow, petition should be written to the EFCC, because once a governor diverts the allocations meant for the local government, the implication is that such diversion, such conversion amounts to stealing. Whereas the governor personally may not be arrested while in office for the period that he enjoys immunity, but it will be a public statement made against his government, and there will be a question mark on the capacity, on the integrity, on the validity of the acts of such a particular state governor. I believe all steps must be taken to put in check the activities of these governors.
Very well said, but I find it a bit confusing when we talk about democratically elected local government officials and at the same time also acknowledge that they are stooges of the governors. So how democratic really is their election? Should we be talking about local government reforms, or we should be talking about electoral reforms? And if we're talking about electoral reforms, we've done that time and time again, but still the process is not as smooth as it should be. So should we be talking about constitutional amendment or writing an entirely new constitution, as some legal experts have suggested? I would just like to know your thoughts on all this.
Yes, it is imperative that we restructure local government administration in Nigeria. The National Assembly has taken some steps by which they believe that the local government councils can be made to be independent, but it is not sufficient, because even in many cases, when some of these governors, when they organize elections, they organize sham elections, and they use the state independent electoral commission to achieve this untoward outcome. And what do? By the time the election will be held, you discover that the opposition will be so either scared out of the electoral process, or it will be so skewed against the opposition that they will not even have the confidence to go into the electoral process with the political party in power. And in such a situation, the people that will emerge from such a sham process will be nominees of the governor, because these governors do not want anybody that will query them. We read recently of a particular local government chairman who challenged his governor with respect to local government allocation. And we saw how all the other local government chairmen came out and they were prostrating, begging the governor of that particular state to please forgive their colleague. In such a situation, what do you make out of that? Now, majority of the people that are in the electoral process in the local government and what have you, many of them are jobless elements who want to be in power by all means. And in the process, the governors too, who want to make sure that they control the local government structure, would rather want their own stooges, their errand boys, to be the ones that will go into these local government councils. So that is why I'm going to agree with you that there must be a complete overhaul, a total overhaul, a total rejuvenation of the process by which local government councils are put in place, that they are being administered and they are being financed in this country. And what do we need to do in this situation? I believe that the body that will carry out the elections at the level of the State Independent Electoral Commission for local government councils should be truly independent. Such bodies must be truly independent. We cannot afford to have nominees of the governor who do not, because for instance, in Osun, the governor just woke up one morning and dissolved the State Independent Electoral Commission. This is a body established by the Constitution with a tenure provided by the Constitution itself. It is beyond, it is ultra-wired, the governor, to dissolve the State Independent Electoral Commission. It doesn't lie within his power. I don't know what our governors think, what exactly they think they are. Now, how can a governor wake up on whatever side of the bed, whether on the right side or on the wrong side, to say he's dissolving a body established by the Constitution and dissolving that body and now recomposing it in accordance with what will suit his own whims and caprices? It is unconstitutional and completely illegal. And that is why the National Assembly, the federal government, must convene an assemblage by which people can make contributions on how the local government system can be reformed in this country. It is not enough to just leave it to the National Assembly to say that, okay, they are amending the law. They have been amending the Constitution. The provision of the Constitution is very clear. And that is why whenever any governor fails to comply with the provisions of the Constitution, a federal government that is worth its salt must be able to challenge the outcome of that process, either by judicial process that will involve the Attorney General of the Federation and Minister for Justice to take, because it is a violation of the Constitution, which cannot be beyond the Attorney General of the Federation to challenge the activities of such a state government, to say you are violating the Constitution. And when there is a dispute between the federal government and a state government, or the two federating units of government in Nigeria, such a particular action will go directly to the Supreme Court, as that is the court that has the power to exercise original jurisdiction in such matters. And the implication is that such matters are supposed to be determined as quickly as possible. Now we have a plethora of decisions, a long line, a chain of cases whereby the Supreme Court has pronounced as regards the illegality, the unconstitutionality, and the aberrations involved in the activities of governors who dissolve local government councils and put in place caretaker committees and divert their allocation, their financial allocation from the federal government. In this regard, the implication is that we have lawless elements who are presiding over the various states that we have in Nigeria, except maybe probably for a few that are conscionable enough as to organize the election. Then the elections organized, how genuine they were, how free and fair they were, is a secondary issue, which we must equally consider critically. And that is why the body that will be organizing such elections at the level of the states must be truly independent. We have the Independent National Electoral Commission, which we believe to some extent enjoys a good measure of independence. At least we've not heard of a case whereby the INEC chairman was ordered to be removed by the president, unlike in the case of maybe CBN and some others like that. But we have, in cases of the state governments announcing unilaterally the removal of the chairman of a state independent electoral commission, or in many cases dissolving the body entirely and reconstituting by putting some party jobbers, to replace such men and women who are maybe properly nominated into such bodies before. So it is in this regard that it is very, very imperative that we must review the local government administration in Nigeria. There must be a stakeholders assemblage, a kind of a conference whereby there will be critical reappraisal. It may have to be constituted by the National Assembly itself in one of its hearings, supported by the federal government, the executives, to ensure that we critically engage this process. And it will involve the state governors too, to make sure that, okay, we drum it into their heads that what they are doing is not only unconstitutional, it is illegal. And it is an act that after leaving office, they can be called to question. But as a primary step, I believe what the Senate is doing right now, refusing to release the allocation of such local government councils where they are not democratically put in place, refusing to release such allocations to them, will put many of these governors in check. I think it will control their illegal activities to some extent. We are not saying that such funds should be shared by the federal government or some, because in Nigeria you can't trust many people with federal, with government revenue. When such monies are meant to be kept somewhere, you just discover that they are looted. But such money should be kept, should go back to probably the federation account, from where they can be kept with the CBN. And when such local government councils are now democratically put in place, the money can be released to them. The implication, just like it happened after the Civil War, that the federal government released the allocations meant for the states, the eastern states that were part of Biafra during the Civil War. Such allocations were kept by the Minister of Finance then, Chief Obafemi Awolowo, SAN. The monies were kept in a separate account, and when the war was over, it was released, it was funneled gradually to those states. And it was the release of that money that assisted majority of the eastern states to be able to reorganize themselves and eventually launch themselves back into prosperity. So I believe such a step will have to be taken, whereby the Senate will put in place a resolution and mandating that for this particular violation of the Constitution, then the government should withhold the allocations meant for those local government councils where they are not democratically in existence.
Well, I hope that some were listening, and we thank you so much for your in-depth discussion today, Mr. Kunle Adegoke. Thank you so much for joining us on this.